The last question that we would like to discuss regarding the Trademark Act of 1999, that is differentiate between trademark infringement and passing off. So regarding that, first we will discuss trademark infringement and how it is infringement. In such case, we gave certain examples like Rediff versus Rediff and Picnic versus Picnic, Playboy versus Playman, and Aqua Care versus Water Care. And in that connection, we would discuss certain important leading cases such as William Grant versus McDowell, a case of 1994, and United Distillers versus Jagdish Joshi and others. It was a case of 2000, and Cadila Healthcare versus Cadila Pharmaceutical, and it was a case of 2001. So, trademark rights are infringed when one party uses a mark of another party, and that is likely to cause confusion in the minds of consumers as to which party is the source of the original goods or services he or she wants to purchase. In determining whether two marks are confusingly similar, courts look at the overall commercial impression made by the two marks from the standpoint of a reasonable customer. Do they look alike or sound alike? Such as Rediff versus Rediff, Picnic versus Picnic. Do different words have a similar or identical meaning, such as Playboy versus Playman, Aqua Care versus Water Care? So, in that connection, we would like to discuss the most important case, and that is relating to William Grant versus McDowell in 1994. William Grant sued McDowell for infringing the trade dress of Glenfiddich Scotch whiskey. The trade dress of Glenfiddich Scotch whiskey consists of the triangular green-colored bottle, black cylindrical cartoons wearing a distinctive trade dress, and a unique feature which included a stag device and a thistle. The trade dress device, the court held that this whiskey had a reputation in India, and the trade dress of Glenfiddich is unique. The court held that the trade dress indicates the source of the product, and that Glenfiddich has the exclusive right to the trade dress, which would be impaired if a similar trade dress was used in relation to a different product. It further held that the copying of the trade dress was deliberate and not incidental, and therefore McDowell's Act is an infringement of the trade dress of Glenfiddich Scotch whiskey. And now we'll go to the second important leading case relating to infringement, and that is United Distillers versus Jagdish Joshi and others in 2000. That is United Distillers, the owner of the trademark Johnny Walker, for a Scotch whiskey sued Jagdish Joshi and others for infringement of its trademark and its trade dress. The defendants were the manufacturers of Johnny Walker Gutka with a logo and trade dress similar to the plaintiff's logo and trade dress. The trade dress of Johnny Walker consists of a two-tone color combination of black and gold on its label. The angled label has a distinctive golden outline and there is a striding figure of a man in a bowler hat. The court held that the defendants use of the logo and get up of the trade dress had an overlap similarity with the plaintiff's trademarks and trade dress. Thus, the defendant had infringed the rights of the plaintiff in its trademark and trade dress. And now we'll discuss the most important leading case in relating to trademark infringement, and that is in between Cadila Healthcare and Cadila Pharmaceutical, and it was decided by the Supreme Court in 2001, disposing the appeal and remanding the case to the trial court in Cadila Healthcare for Fasligo versus Cadila Pharmaceuticals for Falcitab, an anti-malaria drug. The Honorable Supreme Court set out the following general factors for deciding the question of deceptive similarity in an action for passing off on the basis of the trademark, and in relation to that we'll see the exact decision, and that is how it was relating to trademark infringement. So, in Cadila Healthcare versus Cadila Pharmaceutical Limited in 2001, the Supreme Court set out factors that must be considered while deciding the question of deceptive similarity. Factors such as the nature of the marks, word, label, or composite and goods, similarity in nature, character, and performance of goods, class of purchasers likely to buy the goods, and the modes of purchasing the goods are essential components with respect to the question of deceptive similarity in a passing off. So, in relation to that, we'll discuss the very definition of infringement as it has been expanded. So, infringement has been defined under the very Act of 1000, that the Trademark Act 1999, as it defined infringement as use of an identical or similar mark in respect of goods and services to completely unrelated goods or services could constitute infringement. Use of a registered trademark to labeling or packaging materials on business paper or for advertising goods or services constitute infringement. Secondly, in case of word marks, even spoken use of the words can constitute infringement. So also allowing a suit for infringement or passing up to be filed in the court within local limits of whose jurisdiction the plaintiff resides or carries on business or works for gain. So also, courts are empowered to pass ex parte injunction orders or order for discovery of documents, preserving the infringing goods, documents, or other evidences, restraining the offender from disposing of or dealing with these assets in a manner that may adversely affect the plaintiff's ability to recover damages, cost, or other pecuniary remedies. So the minimum penalty of a 6-month imprisonment and arrest 50,000 have now been prescribed for trademark violations. The maximum penalty has been increased from 2 years imprisonment to 3 years and a fine of 2 lakh. So now we will go to passing of actions. So regarding passing of action is applicable in events of unfair trade competition by which one person seeks to profit from the reputation of another in a particular trade or business. This is for the protection of unregistered trademark used by someone other than the owner. The Trade and Merchandise Act, Marks Act 1958 does not define passing off, but only provides the rules of procedure and the remedies so available. So in that connection we will discuss certain important leading cases such as NG Dongri versus Willful Corporation. So of 1996, so in this very leading case it was the decision as an action for infringement, which is a statutory right, is dependent on the validity of the registration mark. So, in that connection, we will discuss another important leading case, and that is Harrods versus Harrodin School of 1996. And here, unlike infringement, passing up is not a proprietary right in the name or the get up that has been misappropriated by the defendant. It is a wrongful invasion of a property right vested in the plaintiff. A passing of action is therefore independent of a statutory right and is established by evidence of reputation and goodwill of business as it was decided in this leading case, Harrods versus Harrodin School in 1996. And now we'll go to another important leading case regarding which we'll found the difference between infringement and passing off, and that is Kishore Jarda Factory Private Limited versus JP Tobacco House, a case of 1999. In a passing of action, the registration of the trade name or a similar mark has no meaning. Here, the priority adoption and use of trademark is superior to the priority in registration, as it was decided in Kishore Jarda Factory Private Limited versus JP Tobacco House in 1999 by the Delhi High Court, and in our last leading case relating to passing off is Messrs. Sinor Laboratories Limited versus Messrs. Jackson Paul Pharmaceuticals Limited, a case of 1999 where it was decided based on the various courts' decision. It is now settled that a prior user of trademark has rights even over a later registered user. The injunction cannot be issued against a prior user of the trademark in a passing of action, as it was decided in this very important leading case, Messrs. Sinor Laboratories Limited versus Messrs. Jackson Paul Pharmaceuticals Limited in 1999. So, in brief, we will discuss the very difference that we found in between infringement and passing off. And as regarding passing off, mostly it confined to trade names, symbols, signs, devices, and unregistered trademarks. And as regarding infringement, action shall be confined to registered trademarks only. And as regarding the second difference in passing off, there should first be misrepresentation and then consequential damage to the reputation and goodwill of another. And in case of infringement, action shall be confined to the acts described or defined as infringement of the rights assured under the statutes such as Copyright Act of 1957, Trademarks Act of 1999, or the Indian Patent Act of 1970. And the next difference in between these two is that in case of passing off, trademark registration is not relevant for taking action against passing off. As in case of infringement, trademark registration is a must to take action against infringement. And the next difference that we found in between these two, in case of passing off action, transactions covered under passing off are non-trading, non-commercial, non-profit making, and professions in addition to commercial transaction. But in case of infringement, transactions are limited to goods and services only. And the next difference that we found in between these two, in case of passing off, every action of passing off does not necessarily result in infringement, as while in case of infringement, every act of infringement has an implied passing off. And the last difference that we found in between these two, in case of passing off, is related to name, mark, symbol, and the offending mark may not be related to same and similar goods of the others. It can relate to the business of the owner of name, symbol, and mark. But in case of infringement, infringement in infringement we found action, registration assume the current use. So these are the very differences that we found in between infringement and passing off. As the very question is that differentiate between trademark infringement and passing off. So in relating to that, the most appropriate and relevant answers that we have discussed chronologically as fast regarding what is trademark infringement and how trademark infringement becomes the subject matter in legal disputes as relating to the very similar sound of similar names, and in relating to that also we discuss important leading cases like William Grant versus McDowell, Souls United Distilleries versus Jagdish Joshi and others, a case of 2000 Souls Cadila Healthcare versus Cadila Pharmaceutical in 2001. And as regarding passing off, we discuss certain other important leading case like NR Dongri versus Willful Corporation 1996, Harrods versus Harrod in School 1996, Solso Kishore Jad the Factory Private Limited versus JP Tobacco House 1999, and the last most important leading case that we have discussed, Messrs. Sinor Laboratories Limited versus Messrs. Jagason Paul Pharmaceutical Limited in the year 1999. So, this should be the relevant and the appropriate answer to the question differentiate between trademark, infringement and passing up. So, we have completed all the relevant questions with their relevant answers that we have selected from the very Trademarks Act of 1999. Almost 6 questions we have selected as per the very important relevant provisions relating to trademark registration, trademark infringement, and trademark passing off. So, in our upcoming video, we will discuss the left out portions of international law regarding treaty provisions.